Hi there, my name is Chris Coons. I'm a bankruptcy attorney.
My name is Kristina Crump. I also practice bankruptcy in Kansas and Western District of Missouri. And today we're going to talk about 5 things to avoid before filing a bankruptcy case.
Right, so these are basic ideas that we encounter all the time in our practice, and it's often too late by the time somebody gets to us if they've done these things to fix them completely or unwind them completely. So we just want to give people kind of a heads up. So can I start with the first one?
Absolutely.
Okay, all right. So we kind of have a little cheat sheet here, but payments on debts to friends and relatives. And I'm going to try to explain why this matters briefly. So when you come into a bankruptcy, you're looking to put everybody on equal footing. And what I mean by that is, let's imagine you have credit cards and medical bills and personal loans. Well, we don't care if the credit cards are with a big bank or a small bank. We don't care if the personal loans are with a big lender or with some individual that you know. We want to put everybody in the same position. So when you file a bankruptcy, the court can look at payments you have made to people prior to the filing, and in some cases, the bankruptcy trustee can claw that money back into the case. Now, with normal creditors, that might only be what we call a 90-day look back, meaning they're going to look back 3 months in the past. But with friends and relatives, when you pay debts to them, the look back is up to a year. So you might have a brother or a sister or a parent, and you might owe them a couple $1,000s, and you're going to file a bankruptcy, and you're thinking to yourself, I'm going to go pay those folks before I file. So you make the payment, and then something terrible happens, a garnishment or a repossession, and now you're in an emergency to file the bankruptcy. So you go in to see the attorney, and the attorney informs you that there's a possibility that a bankruptcy trustee could now go to this relative or maybe even a good friend and try to recover that money. But because you're in a position where you've got to file to stop something more serious, such as a garnishment, you simply have to move forward. We would, of course, prefer that you not have made those payments in the first place. Is that a fair statement, Kristina?
Sure, absolutely.
Okay.
One of the other things, or number 2 on our list, is actually cashing out a retirement plan to pay some of your creditors. Usually not a good idea for a lot of reasons, but one of them is that you're robbing your future self. You probably still have to file a bankruptcy. Some of those things that you're paying off are going to be dischargeable in a case. You might not even have to pay them back, but now you created this taxable event, and not to mention that you probably don't have as much money in the retirement account, which means that when you are 65, 67, you're going to be missing that money and all that interest that you could have collected, accumulated, if you left it alone. So typically not a good idea. Also, if you're borrowing the money and if it's a 401k loan, that is something that you have to pay back, or potentially have, again, tax consequences and penalties on that. So a lot of times that just kind of cuts into your cash flow if you decide to go that route. So whatever you do, do not borrow money from your retirement account to pay back your debts.
Before I go to number 3, Kristina, are retirement loans dischargeable in bankruptcy?
They're not, because your retirement account is actually securing your loan. So if you continue working with that employer, you either have to continue paying it back, or you have to take it as a distribution, which again, tax consequences there.
So number 3 is very similar, and that is taking out a home equity line of credit prior to filing a bankruptcy. If you're going to file a bankruptcy, and let's imagine you have $30,000 to $50,000 of credit card medical debt, and you decide, well, I can get on top of this if I go borrow $10,000 or $15,000 against my house. Well, the problem is that you're converting debt that would be dischargeable to a non-dischargeable secured loan against your homestead. So you really do not want to take out any kind of a home equity loan to pay down on unsecured obligations. You really, if you're at a point where you're even considering this, the first thing you should do is go talk to an attorney to make sure that you're not causing yourself more harm, because you're going to be increasing your output on your housing expense by doing this, decreasing the equity in your home. In a way similar to the 401k, you are borrowing from your future self. So we generally consider these things a bad idea.
One of the other things that people often ask us is, hey, can I just give away some of these valuable things that I might have, be it maybe a third vehicle or a second vehicle, maybe a collection of some sort, something that you inherited from grandma, grandpa. Always a bad idea. Usually there are ways that we can deal with valuable assets that are not protected by law in a bankruptcy. If you start giving away valuable possessions, that's just going to draw lots of scrutiny. You're probably going to cause lots of trouble that sometimes probably wasn't even, the stuff that probably wasn't even meaningful or valuable to the trustee, but now that you decided to give that away, that could create potential issues. Anytime you have any kind of asset that has value and you want to get rid of it, do not sell it to friends, relatives for $5. If you need the money, sell it for fair market value. Get the money, record the transaction, make sure you have some kind of statements to support what happened, because that can create lots of issues in the bankruptcy case.
And our rounding out kind of our 5 things here today is please try not to borrow money where you bank. Now, that's going to sound pretty odd, because if you're at a credit union, quite often the reason you're at the credit union is you got a loan at the credit union. Often if you want to borrow money like a car loan and the credit union wants to finance you, it's mandatory that you open an account at the credit union. And you often have a checking account and a share account. And the share account has a minimal amount of money in it. Now, you still have a loan there, and you may have at your bank a credit card or a personal loan. Well, when you file a bankruptcy, it is very likely that that bank is going to close your account down and arguably set off against the funds that are sitting in the account on the day the bankruptcy case is filed. So most attorneys are going to tell you, if this has already happened, they're going to say to you, please move your accounts to a different bank. And most people have direct deposit at this point, and so you want the direct deposit on paychecks or on Social Security funds or retirement funds to go to a bank where you do not owe any money. And this is something that is fixable, but in a general sense, we try to tell folks, try not to borrow money where you bank if you can help it. It's certainly a fixable item, but it's something we think you should be concerned about.
So just to summarize, if you want to go quickly through the list again. Number 1, do not pay friends or relatives.
Number 2, don't cash out any retirement plans.
Number 3, do not take out a home equity loan.
Number 4, please do not give away valuable goods and items to friends and relatives.
And number 5, if you owe money to the bank where you bank, please consider changing bank accounts.
That's correct. I think that's about it.
If you have any other questions about your options and your financial situation, contact us directly, 785-856-8720.
Thank you. If you need to stop creditor calls, harassment, collections, lawsuits, repossessions, garnishments, or foreclosures, please give us a call. Consultations are free.